contrary, it grew so important and so central that we've learned to take it for granted. What we're talking about when we talk about the law is the soul. So let's start with the Clinton impeachment, if anyone remembers that ancient history from a few years ago. In the opening statements of the impeachment trial of President Clinton, the phrase rule of law appeared 23 times. Indeed, the Senate was told by one of the House managers, what is on trial here is the truth and the rule of law. Henry Hyde, House Judiciary Committee chair, said, the vote that all of us are asked to cast in the final analysis is a vote on the rule of law, one of the great achievements of our civilization. Another congressman called the rule of law our nation's most fundamental value. And indeed, the first article of impeachment charged the president with acting in a manner subversive to the rule of law and justice. And yet, alongside all of the rhetoric of the rule of law, there was a strong current of anti-legalism. In fact, although we all know what the rule of law is, right, laws, not men, I actually suggest that it's men, not laws, and definitely not lawyers. Clinton had already been accused prior to the whole impeachment scandal of lawyerly evasions of the truth, of running a lawyer-filled White House, of legalistic hair splitting, and everyone remembers the president's claim that it depends on what the meaning of is. Really, though, these defenses, if we look at them, were just standard legal practice. My client did not commit a crime. Even if he did, the crime didn't merit the punishment. These were legal defenses. And yet they were seen as incidental to a legal trial, which was ostensibly about the rule of law. It's a very curious juxtaposition, right? Rule of law, fundamental value of our country. On the other hand, no lawyers. Sometimes there was actually overt religious rhetoric. Representative Vic Fazio, in his last speech before retiring, bewailed the impeachment trial as a moment where legalism reigns over human understanding and acknowledgement that we are all sinners before our Lord. Representative Bob Ney, this is my favorite because I wrote this chapter a long time ago, but this month was indicted on fraud and bribery charges, explained that as a Christian country, America should forgive President Clinton for no one is perfect in this life. Representative Ney subsequently voted for impeachment. Even though when there was no explicit religious rhetoric, the anti-legalistic strain was the same. Consider these remarks of Tom DeLay, who called the impeachment process about relativism versus absolute values, and who said he wouldn't allow the president to use legalese and lawyerese to do two steps around the questions. Now, I want to suggest that we could say that all of this is just, of course, partisan zealotry, but I want to suggest it's something deeper than that, and I want to look at two parallel examples. So holding all of that anti-legalistic rhetoric of the Clinton impeachment in mind, let's flash back 210 more years to when in the mid-1780s, a New Hampshire jury was instructed as follows. Do justice between the parties, not by any quirks of law, but by common sense between man and man. This jury instruction was not an aberration. From its inception, actually, the jury was an extra-legal way to determine true guilt or true innocence. It was and has always been the rule of men, not laws. When the jury began in the 12th century, it was seen explicitly as a replacement for the ordeal process. Right? So today, ordeals are associated with superstition and irrationality. Right? So if the witch is guilty, she rises when she's trying to be drowned, but if she's guilty, she drowns, these kinds of things. But actually, they were a sort of sensible, albeit desperate, means of ascertaining factual guilt or innocence within a worldview that was extremely skeptical of legal procedure. Recall that few medieval legal systems possessed any sort of developed rules of evidence or rules when testimony was allowed and when it wasn't. Generally, there were only two forms of evidence that were acceptable, confessions and the testimony of God. Torture obtained the former, ordeals obtained the latter. And I go into this in more detail. Again, there's sort of a counterexample of contemporaneous Jewish law with very detailed rules of evidence. Just go into that into the paper. When the English jury came into being, it was understood as replacing ordeals. Here's Plucknett writing that the jury was, I'm quoting, a newer sort of ordeal. The jury states a simple verdict of guilt or not guilty, and the court accepts it as unquestionably as it used to accept the pronouncements of the hot iron or the cold water. The early jury worked because it, like God, can weigh the soul of the accused and determine guilt, and thus pronounce guilt or innocence. Even in the jury's later forms, it did not require law or even explanation. English juries were never asked to explain their reasoning until the 17th century. And this silence is particularly striking when we remember for most of this period, the jury looked at questions of law, not only questions of fact. Likewise, in the early American context, it was assumed that jurors need not even be instructed as to the law because their deliberative process was one of common sense and wisdom. One 18th century jury instruction, 1759 from Massachusetts, informed jurors that they need no explanation since your good sense and understanding will direct ye to the right outcome. Jurors with no legal training were thought to be good judges of the common law of the land. Standards of evaluating evidence were often matters of conscience. And a 1741 instruction said that the jurors should look at evidence and judge it satisfactory, even if you have no particular reasons in your own breast, if you have no particular reasons in your own breast, in your conscience, rather, to discredit them. In other words, if your conscience doesn't discredit the evidence, admit it. Right? That's not a lazy instruction. That's not a sort of, well, we're not going to do the law here. That is the real law here, right? The law of conscience. And you can just compare some of that instruction to the language of the Clinton impeachment. The paper then goes on in detail to look at more examples in terms of writs and in terms of equity, which for time I won't go into now at all. I just want to choose one last example before turning to the explicitly theological material. And that's the debates around the common law in America. Here again, the same religion-soaked anti-legalism. There's a great, I just can't resist giving this another jury instruction from 1785, I believe. Gentlemen, you have heard that what has been said in this case, you've heard what's been said in this case by the lawyers, the rascals. They talk of law. Gentlemen, it's not law we want, but justice. They would govern us by the common law of England. Common sense is a much safer guide. A clear head and an honest heart are worth more than all the law of all the lawyers. Right? Great rhetoric. Notice, though, the opposition, right? A clear sense, a clear head and an honest heart on the one side, the law of all the lawyers on the other. In 1805, Jesse Higgins wrote that God never intended his creature man should be under necessity to carry a written book in his pocket or a lawyer by his side to tell him what is just and lawful. He wrote it on his mind. And so in the paper, I go into detail about how the common law was itself conceived, and with the Federalists on one side and Republicans on the other side. What I'm interested here, though, is simply that everybody praises the same virtues, regardless of what side of the debate they're on. On the one side, the common law is about natural principles, those rules and maxims, quoting here, of immutable truth and justice. Or on the other side, if you were against the common law, it was about artificialness and technicality. In other words, both sides praise the same thing. They just differ as to whether the common law delivers the goods or not. Right? So no one wants the Pharisaic rules, the Byzantine legal precedents, but rather, quoting, the perfection of reason arising from the nature of God and man and things. And religion here was never far from the stage, right? It was a commonplace that Christianity was part and parcel of the common law. In the words of Justice Kent, at the time Chief Justice of the Court of Appeals of New York in 1811, we're a Christian people, and the morality of the country is deeply engrafted upon Christianity. Enlarged Christianity was presumed to be the very basis of the common law itself. Obviously, that was a controversial position attacked by Jefferson and his supporters. Last time it was invoked was 1927. I don't want to minimize, though, the extent to which the grounding of law in Christianity, or reason, or conscience, legitimizes the law and rescues it from a positive formalist mechanism. So let's turn to